Hi everyone, Eric Rodabois. So I'm going to do a little bit of a deep dive on loans. And let me give you the backstory. So a client comes to me, and unfortunately, people only come to me in one of two situations. They either come to me before, which is the right thing to do, or they come to me after. And when it's after, it's because something's gone wrong. So in this story, the client has loaned $200,000. Now they were speaking directly to a broker, and the broker said, hey, I've got this opportunity, and they never actually had direct contact with the borrower. Now, couple red flags, the borrower prepared the loan documents. Just think about it. Think about walking into a bank and saying, hey bank, here's my loan document. Would you please sign this, bank? That's never gonna happen, right? The bank is gonna say, no, here's our loan documents because it's our money, so you're gonna agree to our terms. So that's the first thing. If you're lending money, always make sure it's your contract and make sure that it's actually been prepared by your lawyer who's got your vested interest. And you can be as one-sided as you want because it's your money, right? And if the other side wants your money, you can dictate most of the terms. So in this story, the borrower gives the contract. Huge red flag, okay? Second part, my guy didn't know the borrower, didn't do any due diligence on the borrower, was solely relying on the broker. Now in this story, the broker actually had a relationship and they had done a bunch of deals together and everything had gone great up to that point. So our guy was going on faith that the borrower was a real person. Well, obviously what happens, the borrower defaults and then everybody, including the broker and the borrower, start ghosting our guy and he's out $200,000. So he comes to me with this loan agreement drafted by the borrower and I'm looking at it and there's some parts of it that are okay. It's got a piece of property that it's supposed to be tied to, although it's not a mortgage. It was not recorded property. It does not state that the property is collateral. So the other things that could have come up if he had come to me before, I would have been like, hey, let's put a mortgage on this property to totally protect you. And so now we're looking, okay, so I look up the property. Okay, the property is owned by the same LLC. That's good. Okay, we're charging interest. So let's talk about interest. If you give a loan with no interest, that's going to be seen like a gift. And maybe the rate of interest you should have been charging is what the IRS would be considering a gift to that other person. Because in real life, nobody gives anything for free. So if you're giving a loan to a family member and you're not charging interest, the IRS would consider at least the unpaid interest, the uncharged interest, a gift. So you need to charge at least some amount of interest. Now, the question is how much? Now, this is going to come down to state specific. A lot of times when you look at a loan document on the back where it says the choice of law, it'll say this loan is pursuant to the law of Maryland or Massachusetts or New York or Florida, or the fancy one nowadays is people use Nevada and Utah, because guess what? Nevada and Utah, you can charge any interest rate you want. You can charge 1,000,000% interest, and in Utah, that's fine because they don't have what's called a usury law. Usury is the crime of charging too much interest. So in Florida, the maximum allowable rate of interest in most loans, there are exceptions, is 18%. In Maryland, it's 8%. In Massachusetts, it's 20%. So you got to know the law. Now, this particular note was for buying a piece of property in Florida, so I'm going to infer that it's Florida law. However, it doesn't say. There is no choice of law provision. So in my story, a Maryland person is loaning money to a Massachusetts person to buy Florida property. Which law applies? That's a great law school question. And so in Florida, if you're over 18 but under 25, that is called, that's a civil violation of the usury law, and you might lose all your interest, but you can still get your principal back. If you charge more than 25, you lose the principal. Meaning you lent $200,000, you charge 30% interest, you lose the whole thing. It's called criminal usury. So you need to be very careful if you're lending money and you don't know what's going on. And in my story, my guy thought it was 15% rate of return after 6 months. Well, guess what? That's 30% annualized interest. That makes it a criminally usury loan. However, my guy didn't read the thing he signed because what it actually says is 15% annual interest. So it's like, oh, thank God. He's actually charging a correct rate of interest in Florida. But what about Maryland? Maryland, it's 8% is your maximum interest. Anything above 8 is criminal. In Massachusetts, it's 20%. So we would have been okay at 15, illegal at 30 everywhere unless it's Utah or Nevada. So again, when you're lending money, you need to talk to a lawyer, you need to know what the rate of interest is, you need to know the choice of law, and hopefully you're gonna call me before you lend $200,000 to a stranger and not after when they've ghosted you, and now we gotta talk about your litigation possibilities. Thanks, guys.